was a slight lag between what it was and not.
My lords, I'm going to move on from the place of delivery shortly, but I did just want to explain briefly why I'm making so much of these points.
Yeah.
Mr. Carl's primary case on appeal is that the contract was terminated because of GFL's emails in February 2018, which insisted upon delivery in London and a right to inspect. So that's his primary case as to why there was a termination, and that's therefore why I'm looking at this place of delivery point in detail. It's only his secondary case on termination that engages the fee issue. His secondary case on termination is that in bringing a claim premised on there not being an entitlement to the fee, that was a repudiatory breach of contract which he purported to accept by his reply to defence to counterclaim. That's his alternative case on termination. So insofar as that helps, that's why I'm making so much of these issues, because of what's said against me.
Well, I know there's a lot about all these issues in the skeleton arguments, but when I asked Mr. Shepherd what difference does the termination issue make, his answer was not much, maybe costs.
I appreciate that, my lord. I have to say I slightly struggle to follow that, because if that's the case, then the specific performance order stands and the gearbox is delivered to GFL. My understanding was that the entire basis of this appeal was that Mr. Carl wanted the gearbox back, and so was trying to undo the order for specific performance of the contract on the basis that the contract had been terminated either in 2018 or via the bringing of the claim itself.
Well, I had understood that the reality of this situation was not that Mr. Carl wants a disembodied gearbox, but that he wants $500,000.
He doesn't say that in the grounds of appeal. The grounds of appeal are premised on the contract being terminated. There was a ground of appeal advanced at issue 20, which is at A25, which was that the judge was wrong to reject Mr. Carl's case for declaratory relief. The case for declaratory relief advanced was that if he was wrong that the contract had been terminated, he only had to give the gearbox up in respect of the fee. Permission wasn't actually granted, as I understand it, on issue 20. So as my understanding was that this was all about giving the gearbox back on the basis that the contract was terminated. So as I understood Mr. Carl's position, it is rather simply that he just wants the gearbox. He doesn't even want damages in the sum of the fee. Initially, a counterclaim was advanced for damages for loss of use of the fee, but not in the sum of the fee itself.
Well, issues 2 and 3 say the judge was wrong not to award the fee, or to say that the fee wasn't due.
Oh, sorry, my lord. When it comes to relief, as I understand it, the way this fits together is that because Mr. Carl's position is that the judge was wrong not to find an entitlement to the fee, on Mr. Carl's case, there was a repudiation breach of contract in running a case that there was no entitlement to the fee. And that was his defence of specific performance. Our case below was in the alternative, that if there to be specific performance, it would be specific performance in that the gearbox would be delivered and the fee would be paid. That was our alternative position.
Could we look at the grounds of appeal? I'm looking in at So this is section A2 of the core bundle. And I'm looking at paragraph 17, which is at page A20 in hard copy. Quite a lot in there. Paragraph 17 and 18, what's all that about?
Well, that as I understand it, my learned friend's appeal, but as I understand it, that goes to the issue of whether the judge was right to hold that there was no entitlement to the fee. If the judge was right about that, then in advancing a case that there's no entitlement to the fee, that the GFL was not in repudiatory breach of contract and the contract can't have been terminated via the reply. If the judge was wrong about that, then in advancing a case that was no entitlement to the fee, as I understood it, Mr. Carr's position was that was a repudiatory breach of contract, which he accepted via the reply.
Yes, I understand that people have set up so many issues in this case that they can't all be consistent with each other, or many may not be consistent with each other. And I can understand you making a submission that Mr. Carl at some points appears to be arguing for one result with certain consequences, at another time for another result with certain consequences, and then still a third result with further different consequences. I can understand the inconsistency argument, but what I was trying to establish was that you seem to be saying it wasn't part of Mr. Carl's case, that he wanted you to keep the gearbox and to pay for it, or to pay for the work that he had undertaken in getting it. And in issues 2 and 3, at first blush, those appear to be on this territory, don't they? Whether they're consistent or inconsistent with anything else. But another way, if Mr. Carl doesn't want $500,000 out of this, I don't know what else he does want.
My lord, my understanding was that he wanted the gearbox back, but not $500,000. But insofar as...
So where do we get, I want the gearbox back?
Because Mr. Carl is trying to set aside the order for specific performance, which required delivery of the gearbox on the basis that the contract's been terminated. So as I understand his case on appeal, if he's right about that, then the gearbox has to go back to Mr. Carl.
Well, all of that's by a process of extrapolation, which may or may not be helpful, but can we at some stage deal with the issue as to whether, as to what your case is in response to issues 2 and 3?
Of course, my lord. That was what I was going to come to shortly. I just thought it might... I was tempted to be useful to set out why it was I was getting...
No, you were usefully circling the issue, but we can now come to it.
Great, my lord. If I may just very, very briefly wrap up on section 29(2). I respectfully agree with my lord's point shortly before the short adjournment that section 29(2) lends itself to an interpretation whereby the parties know the place of the goods at the time the contract is made, and that can't apply in this situation because of clause 7.2 of the contract. That then takes us to Mr. Carl's residence. Mr. Carl's clearly described in the contract as being of Chester Square. In my submission, one doesn't need to go any further than that. In circumstances where somebody has multiple references, deference to the contractual address makes perfect sense. And consistently with section 29(2) of the Act, insofar as delivery needs to take place at the buyer's residence, one should look at the residence as the address as set out in the purchase agreement.
Is there any law on section 29(2), in particular on the point whether the parties have to know the location of the goods? I mean, section 29(2) presumably was in the 1893 Act as well as the 79 Act. I haven't looked up to see if that's right, and has therefore been around for a long time, and even then reflected the common law. Can you help us on that at all?
Yes, my lord. In light of the questions advanced before the short adjournment, I did have a look at that over the lunch adjournment. I couldn't find anything specific addressing this particular point. Curiously enough, the editors of Benjamin simply cite this case at first instance, which is particularly helpful. But I haven't found anything particular addressing that point, I'm afraid.
Yes. All right. Thank you.
So as to residence, I say we don't need to go behind the agreement. It's right that in examination at chief at trial, Mr. Carl said that his residence was in Florida. There was nothing to suggest that the parties knew that at the time. And in circumstances where the contract says of Chester Square, we can leave it at that, so to speak. There was no correspondence between the parties around the time the contract was made relating to Florida. There was some correspondence relating to Washington, D.C., but nothing about Florida. Very briefly, I'm not sure the degree to which this is even an issue, but on the costs of delivery, the common law rules applied by the judge that the costs of making delivery be borne by the seller. I provided the reference for that in my skeleton argument, but it's recognised in Benjamin, and that's at tab 38 of the authorities bundle, and the judge cites it at paragraph 153 of the judgment. Unless I can insist further on the place of delivery and the cost of delivery, this takes me to the fee point, my lord. So if we go back to clause 7 of the agreement, and I'd like to start with clause 7.4. So in consideration of the buyer accepting the GTA without the gearbox, the seller agrees to use his best efforts to recover and deliver up the gearbox to seller, as further described below. Obviously the second reference should be to buyer, another infelicity in the drafting. But in my submission, what this demonstrates is that ordinarily the gearbox could be rejected, sorry, the GTO could be rejected without the gearbox, but in consideration of not rejecting it, the seller agrees to use his best efforts to find it, as further described below. So the consideration that he's getting for his efforts to go and find the gearbox are the buyer not rejecting the GTO. That's my submission to the effect of clause 7.3. 7.4 rather. Then at clause 7.5, after completion, sellers formally to engage with Canepa and such other third parties as shall be necessary in the attempt to locate and deliver up the gearbox. So 7.5 rather, relates back to 7.4. So in my submission, this is the description of what the seller has to go and do in consideration of the buyer accepting the GTO without the gearbox. Then we get to clause 7.6. So if he recovers it from Canepa, he'll promptly turn the gearbox over to the buyer, the seller, but it should be buyer, without additional compensation. My learned friend says that the words additional mean that must be not in additional to the payment of the fee, because he says that otherwise there's no effectively consideration for Mr. Carl going about to try and find the gearbox. But what I say is that that consideration is provided for in clause 7.4. So he has to go and run around and try and find the gearbox, because otherwise there would be a right on GFL to reject, which it waives.
So if we were to strike out 7.4 from the contract, the buyer would be entitled to reject the vehicle when it's tendered without the gearbox.
Yes, my lord, that's my submission.
That would be about the most daft contract you could ever make, wouldn't it?
Well, it would be part of the, it would go back to this situation where you're buying the GTO with the original gearbox, but you know that you're not getting the original gearbox as part of the GTO. So you say, well, I'm not going to reject it because it's not whole, and in consideration for me not rejecting it, I'm going to go and ask you to find the gearbox.
But it is whole if what you are offered is a car without its original gearbox.
Yes,
then you get what you've been told you're going to get.
And it's acknowledged at 7.1 that that's what you're going to get.
I mean, your submission suggests a degree of subtlety in the drafting of clause 7.4, which the rest of the agreement doesn't really bear out, doesn't it?
Perhaps, well, my lord, I'm simply trying to identify how clause 7.4 is reasonably clear, I would submit, on its terms, that what the seller has to go and do is in consideration of acceptance of the GTO without the gearbox. So that right, if you like, is being waived within clause 7.4. in exchange for the seller going about to use its best efforts to recover and deliver up the gearbox. So then when you get to clause 7.6, that makes sense because there's already been consideration for Mr. Carl going to try and find the gearbox. And then clause 7.6 operates as complete code, if you like, as to what happens with when the gearbox is recovered from Canepa. And when it's recovered from Canepa, it's simply turned over without anything further.
So is clause 7.7 a complete code when it's recovered from somebody other than Canepa?
Clause 7.7 doesn't actually address recovery. So clause 7.7 is when it's located in the possession or ownership of a third party as distinct from recovery. The recovery obligation in clause 7.7, in circumstances where it's recovered from a third party other than Canepa, is set out in clause, or my submission set out in clause 7.10 and 7.11 together. And I can come to this, but you can see to a degree that that makes sense when one looks at 7.11, which is the fee clause. Because 7.11 recognises that the fee is going to be consideration for services in locating and securing possession of the gearbox. But in a in a Canepa situation, he hasn't really located it because that's where he thinks it is. But in a third-party situation, he has located it.
Well, 7.5 talks about attempting to locate and recover, and that relates to Canepa and any other third parties. So it does envisage locating and recovering, even in relation to Canepa.
I follow that, my lady. My response to that would be that when one looks at 7.2, he obviously thinks that it is at Canepa, and he's already corresponded with Canepa regarding its whereabouts.
But it may still require formal legal correspondence to enable him to recover it.
From Canepa?
Yeah.
It might do, but I would say that the effect of clause 7.6 is that in those circumstances, there's no in order for the legal correspondence to be relevant, it has to concern recovery from an entity other than Canepa, because clause 7.6 is pretty clear on its terms that you don't get any further compensation when you recover it from Canepa. As distinct from when one looks at clause 7.7, the thing that he's got to do without any additional compensation at the end of 7.7 is to cooperate with the buyer. So he might still get compensation for recovering it or locating it if it's located from a non-Canepa party, because 7.7 doesn't provide him with any clause 7.7 simply says that he has to give his full cooperation and his efforts to the buyer without additional compensation. He might get compensation still if he recovers it from a third party other than Canepa under clause 7.7. And that's then what's envisaged in 7.10 and 7.11. But that's distinct from 7.6, where the recovery itself leads to it being turned over without additional compensation.
So what your case is that no matter how hard he tried and how much expense he went to, he was never going to get paid for getting it back from Canepa.
If it was ultimately recovered from Canepa, yes, my lord.
I'm just wondering where the incentive is. I mean, looking at the obligations that are provided, he's got to use his best efforts to recover and deliver. 7.4, got to immediately engage with, including Canepa, an attempt to locate and recover. And then if he recovers it, he's got to turn it over. So those are all obligations which Mr. Carl can decide for himself how much effort he wants to go to, but none of them are going to be in any way to his advantage. Is that it? Is that the reading that you advance?
Well, broadly, yes, save for the point I made in respect of clause 7.4.
Which is?
Which is that insofar as he's got an incentive to use best endeavours, that's in consideration of the buyer accepting the GTO without the gearbox.
But by now you've accepted it.
Yes.
Yes. So it may be right, but your interpretation of this contract doesn't incentivise the recovery of the gearbox by the person who's best placed to recover it. It's just being done in order to comply with a contractual term for which there's no bonus and no very obvious penalty.
As regards Canepa, yes, my lord. Yeah. Save that I think there's a finding in the judgment that it was considered that Mr. Carl might want to pursue Canepa for damages, insofar as he might have got a higher price for the GTO had he been able to deliver it with the gearbox. So I suppose if he so as regards his incentive to provide it to GFL, my lord's right, but it was envisaged that he might want to sue Canepa for damages for the inability to deliver it up, because he then might have got more money. So I suppose if he is able to deliver it up after the event...
I don't see what his damages would be, seeing he wasn't entitled to anything for delivering it up.
Well, he might... This goes back to the point I was making, my lord, about the price negotiations. So it was initially envisaged that it was going to be $44.5 million with the gearbox.
Yes, I remember that. What's 7.8 about?
7.8...
7.8 is a lot of material about the cost of correspondence and litigation. To what extent does that discriminate between Canepa and other third-party possessors?
Well, on its terms, my lord, I don't think it does. It's to do with the sharing of litigation costs in order to secure the recovery of the gearbox.
You accept, do you, that 7.8 does cover correspondence with Canepa?
Well, no, my lord, because when I'm looking at 7.6, essentially in the Canepa situation, what I say is that you draw a line under clause 7.6.
Yes, I see. So you
don't go further.
Effectively, and we've understood this, you want us to draw not just a line, but a quite thick, bold line under paragraph 7.6, and interpret everything that follows it as applicable to a non-Canepa situation as dealt with in 7.7.
Yes.
But in answer to my Lord Justice Peter Jackson, you said that 7.8 doesn't discriminate between Canepa and other third parties.
No.
Are you saying that it...
In its terms.
In its terms.
In its terms, but when it given you've got clause 7.6 above it.
Oh, so you say we should infer that it does?
Yes, because of clause 7.6 operating as a complete code with regard to recovery from Canepa.
So it does in that sense.
Yes.
But in fact, we can go through the rest of the terms of paragraph 7. There's no need to do it in a sense. None of those terms discriminate between recovery from Canepa or recovery from a third party.
Not on their terms, other than if you draw the line, my lord. Exactly.
Yes.
Yes. So when you have references to such formal correspondence in clauses 7.9, 7.10, and 7.11, those all concern formal correspondence. I think as envisaged in clause 7.8.
Yes.
In my submission, that doesn't apply in a Canepa situation.
Now, I know that common sense is not the first port of call when construing a contract, particularly a badly drafted contract. But from anybody's point of view, what's the commercial sense in having one contract for a recalcitrant third party and another contract in relation to recalcitrant Canepa?
Well, I think this goes back to the point that's made at clause 7.2 of the contract, my lord, which is that Mr. Carl thought this was at Canepa. So it might have been envisaged that it would be a relatively straightforward exercise. As in the event, it was relatively straightforward. I think 2 letters were sent by Mr. Carl's lawyer, and Canepa did set up the release fee, but it was a relatively straightforward exercise to get the gearbox back from Canepa. But it might be a much more arduous, complex exercise to get it back from a third party where Mr. Carl wouldn't even know where to go to, who to look for the gearbox. So that there is a sense in there being a distinction between the Canepa party, where everyone thought it probably was, weren't sure, and anyone else.
So the belief was that Canepa would cooperate entirely, that he knew where Mr. Carl knew where the car was, where the gearbox was, and believed Canepa would cooperate and it would all be pretty straightforward. And that, you say, is the distinction between Canepa and third parties in this code.
Essentially, yes, my lady. Canepa itself hadn't been able to find it. There's the points in the judgment that were raised earlier about it might have gone to some disgruntled former employee of Canepa, but ultimately Canepa is where Mr. Carl thought it was, and that would be a relatively easy, in theory, endeavour to get it back off Canepa if Canepa had it. Whereas the endeavour in getting it back from another third party might be quite different and much more onerous.
But the premise of 711 is that there is going to have to be formal correspondence or legal process. So even if it's with Canepa, the entitlement to the fee is not going to be there if it's easy, but only if you've got to go to the stage of formal legal correspondence. Now that may not be all that demanding if it only involves writing 1 or 2 letters, but nevertheless it's a hurdle you have to jump before you are in fee territory. So what's the sense then of distinguishing between formal correspondence with Canepa and formal correspondence with another?
I think it goes to the same point, my lord, that formal correspondence with Canepa was not envisaged to be particularly onerous because that was where it was anticipated the gearbox was. And I'm not bringing this in I'm not bringing in subsequent conduct to interpret the agreements as such, but what ended up happening, as I said, were two paragraph letters sent by Mr. Caputa to Canepa, and that, as the judge found, I can't go behind that factual finding, secured recovery of the gearbox.
Why should it matter to Mr. Fisken how onerous it is for Mr. Carl to get the gearbox back from somebody? What Mr. Fisken cares about is getting the gearbox so that he can put it back into the car and enhance the value of the car because it's got its original gearbox and it's more enjoyable to own, presumably.
Well, I suppose from a commercial sense perspective, one's talking about a flat fee here of $500,000. So this isn't a fee that's calculated by reference to the degree of work that Mr. Carl's actually doing. One's paying a flat fee of $500,000. So if it's very, very easy for Mr. Carl to send a couple of letters off and get it from Canepa, $500,000 isn't a very attractive thing to pay him to do that for.
If one looks at this in another light, it might be said that 7.6 and 7.7 are twins. Canepa for the one and a third party for the other, and that everything that follows, which is preceded by if preparation of formal legal correspondence, etc. Every paragraph after that refers to such correspondence. And that in effect, if one was drawing lines, one would bracket 7.6 and 7.7. And what follows in 7.8 on onwards applies to both of them. Isn't that the natural meaning of this?
Well, my lord, I would say that doesn't give effect to clause 7.6 being on its terms quite clear as a complete code as regards recovery from Canepa.
Well, I think we've probably been around this a couple of times, and either we think that 7.8 and the following apply equally to 7.6 and 7.7, or we think we draw a line under 7.6 and it applies only to 7.7. There's not much more one can say about it, is there?
Perhaps not, my lord. I think I've said everything I need to say on it.
Because also, if one turns to, and you've said you don't want to look at subsequent behaviour, but I mean, the judge found, didn't he, that all the 3 people who ought to have known what this meant thought that the fee was payable.
Yes, which is one of the reasons why it wasn't said to be, the 21st of February emails weren't said to be a repudiatory breach of contract on the basis of denying an entitlement to the fee, because they were sent on the basis that he would get the fee. And in the court below, Mr. Carr advanced an estoppel by convention argument on that basis, which was dismissed.
So it's a curious outcome for your construction of drawing the line under 7.6, is that it's a line that would have been drawn in litigation, but it wasn't drawn in the minds of those who actually negotiated this agreement.
Quite, my lord, but then I suppose it's very much not unheard of for parties to interpret the agreement subjectively in a way which is very different from the correct.
Well, it's very common for parties to interpret an agreement subjectively in their own interests. I understand that, but here they were unanimous in their assumption, at least, that the fee was payable.
They were, my lord, but
yes, right. Well, I mean, maybe the legal outcome is otherwise, but it's a feature of the case which is fairly striking.
The judge found that Mr. Fisken and Mr. Macari were mistaken about that, because that was in accord with his objective interpretation of the agreement and the entitlement to the fee. Before moving on from this, the one final point would just be to note that 7.6 and 7.7 are different in what they say that Mr. Carl, I've made this point, but what they say Mr. Carl gets for no further compensation.
So one is recover and the other is locate. Is that the point, or is it a different point?
He doesn't actually, under clause 7.7, it doesn't say that he can't have further compensation for locating the gearbox. It says that he can't be compensated for providing his full cooperation to the buyer's efforts. The buyer may undertake to recover the gearbox, and Mr. Carl shall do that without additional compensation. So there is a distinction.
Yes. All right. But the fee?
That is the fee, unless I can assist further on that. Sorry, my lord, that was that's the fee as regards when one's entitled to it under clause 7. A point I just other than clause 7.11, a small point just to pick up on clause 7.11 itself is that the entitlement to the fee actually only arises upon being in receipt of the gearbox.
So we're now looking at 7.11 for its terms.
7.11, my lord.
Securing possession.
So that's so this is what the fee is consideration for, and then on the fourth line.
You must make a payment upon being in receipt.
Upon being receipt, quite my lady, yes.
Where does that point go? If there is a valid tender, then presumably Mr. Fisken can't avoid liability for the fee by refusing delivery of the gearbox.
That goes back to the point, my lord, I think, about what the delivery obligations were. So he's not obliged to pay the fee until he is delivered the gearbox, essentially, depending on what delivery means in this case. I would submit that it can't be right, however, on the interpretation of this clause, that there's an obligation to pay $500,000 before you've verified the gearbox, just as a matter of construction and how the gearbox is defined. But once you've got the gearbox and it's been delivered to you, whatever delivery means, whether that's under a tender for delivery or the sending of the gearbox to GFL, once it's been verified that it's the gearbox, then the $500,000 would need to be paid.
This is where the delivery point hooks, because you say that you're correct that it had to be delivered to you, and therefore, as you were not in receipt of the gearbox, you had no obligation to make a payment.
Yes, my lord.
But you are now.
Yes, my lord.
So has the judge held the contract was still extant? So has the fee obligation, if you're wrong on 7.6 point, So if you're right about that, then it doesn't arise. But if you're wrong about that, has the obligation accrued now?
Yes. If I'm wrong on the construction to clause 7, and the fee is payable when it's recovered from a non-party other than Canepa, the gearbox has now been received, it's now been verified, it follows that the fee is payable.
So there's no separate argument remaining about formal correspondence or legal process and that sort of issue. That's been dealt with by the judge.
The judge's findings of fact stop me from making that argument, my lord.
That's very clear.
That is the fee, and that takes me to breach of contract and termination, which my learned friend dealt with briefly. I could deal with it very briefly as well. I foreshadowed it, I think, to some degree in my submissions, but there are 2 allegations of breach of contract and termination. There's the 21st of February emails. They only go to whether there's a right to deliver, whether GFL's right has a right to insist on delivery at its premises, and whether there's a right to verify. If you're with me on those points, then the 21st of February emails could not have been sent in repudiatory breach of contract. Alternatively, if you're not with me that the delivery place needs to take place at GFL, but you're with me that the delivery place is Mr. Carl's residence in London under 29(2) and the terms of the contract, then my submission is that it can't possibly be a repudiatory breach of contract to insist on delivery 2 miles away. To put it in geographical perspective, Mr. Carl's residence in the contract is in Belgravia, GFL's office is in South Kensington. In an international sale contract like this, it can't be a repudiatory breach of contract to insist on delivery in one of them.
Would you say that if it was delivered in the States, the judge has found it was a repudiation?
He has, my lord.
Yes. Could we just see where he says that?
Yes. I don't have the reference precisely to hand, but I can find it. So I think it's paragraphs 174 and 175, my lord. And I don't. It's not a clear finding, but what he says at paragraph 175, second sentence, is that when Mr. Carl purported to accept Mr. Fisken's repudiatory breach, that was a valid acceptance, so it would bring the contract to an end. And that must presume that the 21st of February email was in repudiatory breach, which would only be the case if delivery was to take place in Canepa, California.
It's all very dense, isn't it? I mean, when one considers that, as you've told us, that we're talking about $10,000 in a multi-million-dollar contract. Just trying to understand why it's repudiatory. But, that was the finding.
That was the position the judge reached.
Well, I suppose because on this hypothesis, the buyer was refusing to take delivery of the gearbox.
Well, perhaps, my lord, what the buyer offered to initially pay for the costs of shipment to London, then send it to Ferrari factory in Italy. If it's the right one, pay Mr. Carl the fee less the cost of shipment.
I mean, speaking personally, I find it quite hard to see why it was actually that these parties did fall out so badly, because they all agreed the fee was payable, whether they were right or wrong about that. There seemed to be some consensus that it could be sent to Italy at some point, and the costs involved, whether send it to London or to Italy, were trivial. Quite why it has turned out so badly is puzzling to me.
I can see that, madam. I don't demur from that.
We're talking here about repudiatory breach of a contract for 44 million. We're not talking about some subcontract for a part.
Indeed, my lord.
Yes.
For the court's note, the email that is said to be a repudiatory breach of contract is extracted from the judgment at page B24. And there were two emails sent by Mr. Fisken that day. They're largely in the same terms. They're at little n and little o at the bottom of the page. And then the email that's quoted at little p on page B25 is the purported acceptance of the repudiatory breach.
Right.
Now, the judge found that in light of his interpretation of the agreement, that the email at little p
Read on to paragraph 48. What Ferrari was being told.
Yes, on the judge's findings, and his interpretation of the agreement, he found that the email at little p, the one sent by Mr. Carl purporting to terminate the contract, was in itself a repudiatory breach because it was a wrongful termination. But GFL affirmed the contract and it subsisted. The second allegation of repudiatory breach of contract is this point about advancing a case that there was no entitlement to the fee. Now, if the court's with me on when the entitlement to the fee arises, then this can be put to bed. And if the same applies if the court's with me that the entitlement to the fee would only arise upon receipt of the gearbox. And so in my submission, this can't arise. I do have one additional point to make, which is, I suppose, a technical point, but an important one. which is that the advancing of a case by GFL that Mr. Carl was not entitled to the fee wasn't treated as a repudiatory breach in Mr. Carl's defence and counterclaim. To the contrary, if one looks at the defence and counterclaim, which is at tab B6 of the core bundle, and turns to B95, he counterclaimed for declaratory relief that the agreement was repudiated and that the repudiation was accepted, but that's on the basis of a repudiatory breach on the 21st of February emails, not on the basis of advancing a case that there was no entitlement to the fee. And then at paragraph 32 of the defence, he says if which is denied the agreement is extant, then he sought declaratory relief in respect of it. It wasn't actually until he filed his reply to defence to counterclaim, which is in the supplementary bundle, at tab F17, page 133, paragraph 6. That he advanced the case that GFL was in repudiatory breach for bringing a claim that there was no entitlement to the fee. And I appreciate this is a technical point, my lords, but strictly this is something that should have been contained in the defence to counterclaim and declaratory relief sought in respect of it, and none was sought in the reply itself. Unless I can assist further, those are probably my submissions on the appeal. I was going to propose to move straight on to address my cross appeal.
Yes, please. Where do we most conveniently go to start this?
So, my cross appeal, the best place might be in my my skeleton argument, my lords.
Yes. This A10.
I beg your pardon, my lord?
A10.
Yes, A7, my lord.
I see. Not in your supplementary skeleton argument, but your...
Yes, my first skeleton argument was a response to the cross appeal and my submissions in support. Sorry, my response to the appeal and my submissions in support of the cross appeal.
Right.
It's
Thank you. So, page?
A113, my lord.
Thank you. Yes. You start at paragraph 75.
Yes, my lord, indeed. Now, a lot of the submissions that I make here in writing are similar to the points I make about the Sale of Goods Act applying to the contract, because they concern whether property was to pass in the gearbox. So, if we're agreed that property was to pass in the gearbox, which I think everybody is agreed, the question is whether there's going to be a price for that and when, then we need to look at the provisions of the agreement itself, which make no distinction between when property was going to pass in respect of the GTO and when property was going to pass in respect of the gearbox. So, if I could take you back to the purchase agreement and clause 5, which is at B97. These provisions apply to the GTO, and they talk about the passage of title being reflected via a bill of sale and then eventual delivery up. But in my submission, there's no reason why, if the transaction was to include the original gearbox, and so the price included the gearbox, why property should not pass in the GTO at the same time as it passed in the gearbox. Now, there's a difficulty, because what that would mean is that property passes in goods that people don't know where precisely they are at that time. But that's not a reason for saying that property in those goods did not pass. It just means that people weren't sure where they were at the time of that passage. And there's no separate bill of sale for the gearbox. And so if title was to pass, it makes sense for it to pass at the same time as the rest of the car. A lot of points were made below about why passage of property wouldn't pass at the same time as the GTO. Only one of them found favour with the judge, and that's the limit of my cross appeal. And what the judge found was that clause 7.12 of the agreement, which is at B99, was consistent only with title remaining with Mr. Carl until such time as the gearbox had been, the judge finds, turned over, but effectively delivered. And that was the entire basis for saying that property in the gearbox couldn't have passed at completion at the same time as the GTO.
Because if you didn't own it, you couldn't sue for it.
The judge's reasoning was, sorry, yes, my lord, exactly, yes. So that's why my alternative case for delivery up under the 1977 Act failed. But what, but the judge's reasoning, as my lord says, was that because the clause 7.12 presumes a reservation of right for Mr. Carl to sue for delivery up of the gearbox, which must mean that he retained property in it. And that was what the judge reasoned at paragraph 180.
That might mean that title in the gearbox never passed.
Until just now, effectively, my lord, when it was delivered under court order. If the judge is right, yes.
Because it's only a reservation of a right to Mr. Carl to sue somebody else for it. Not an obligation in this part of the
Not an obligation, no, my lord.
agreement.
The judge recognised that Mr. Carl might want to go and take action if he could never recover the gearbox. So I think that was the intention behind this particular clause. But the question for the court is whether that clause is consistent only with title in the gearbox remaining with Mr. Carl pending delivery.
Well, being no specialist, I'd assume that if I entered into an agreement to deliver an object to you, and it happened to be with some third party, and I was under a legal obligation vis-à-vis you, that I might have a go at getting it back from the third party who had no right to it.
My lord, yes, and that's not inconsistent with property in the gearbox having passed to me.
Yes, so it's nothing to do with whether I do or don't own the gearbox at any particular time, or the item at any particular time. It's whether I've got some right in law of whatever country we're talking to pursue and get it back in order to pass it on to you.
Quite right, my lord.
Right, so that's your argument, is it?
That's my argument. That in fact was going to be my very next submission, which was that there's nothing to suggest that Mr. Carl couldn't have brought an action against anybody in any part of the world, wherever this gearbox was, on a premise that wasn't connected with his ownership.
So as a former owner trying to tidy up
Exactly.
his sale, or something of that sort.
Yes. And this case, because the judge found that property hadn't passed, this case is actually an example of somebody securing delivery up a property not based on an ownership right, but based on a contractual right. So that there really is nothing inconsistent with property passing at completion and Mr. Carr having a right to go and sue for delivery up.
I'm not entirely sure I understand clause 712. Leave aside recover any losses, because I can understand that. But if Mr. Carl is reserving a right to take action against a third party to procure the delivery up of the gearbox, presumably if he succeeds in getting it, he's got to turn it over to Mr. Fisken as per the preceding paragraphs of the clause. I mean, what are the circumstances, if any, in which successful proceedings to procure the delivery up of the gearbox could result in Mr. Carl keeping the gearbox? There aren't any, are there?
my lord.
So what that's all about, over and above the preceding paragraphs, as I say, leave aside the second half of it, I'm afraid I don't understand.
Well, it's a curious provision, my lord, and obviously the second part of it is completely consistent with property in the gearbox having passed to GFL. There can't be an issue about that. Mr. Carl can go and sue anybody he wants for...
Oh, that all makes sense.
That all
Yes,
makes sense.
I follow that.
Well, is it there as I think might have been suggested at some point, in order to for Mr. Carl to be able to wave at somebody who had no right to the gearbox? Say, you know, I may not own the gearbox, but this is what we're doing here, and it can do no harm to anybody that clause was included.
Quite right, my lord. And again, the premise of my lord's question is that in those circumstances, Mr. Carl doesn't necessarily own it.
Yes. Okay.
That's the that is effectively those are my submissions on the cross appeal. Property having passed at completion.
Well, hold on. Where does that take us? What does this actually go to?
So if I'm right about property in the gearbox having passed at completion, that means that at the time at the time of the bill of sale, so at the time the property passed in the GTO, property also passed in the gearbox.
Yeah.
That means that Mr. Carl was wrongly holding the gearbox, and GFL should have been entitled to delivery up under the Towards Interference of Goods Act 1977, because he had immediate right to possession. That was refused by the judge, but only on the basis that the judge rejected my submission that property had passed at completion. So if property has passed at completion, then the question is only whether the court should exercise its discretion to make an award under the 1977 Act. The considerations for doing that are the same as when one is considering making an order under Section 52 of the Sale of Goods Act, which is specific performance of an obligation to deliver goods. And the judge awarded specific performance of the contract. So his reasoning on specific performance, which is essentially that this is unique goods, the damages are an inadequate remedy, you need to put the car back together, GFL's reputation will be enhanced by putting the car back together. etc., all of which are contained in paragraphs 186 and 187 of the judgment, apply in exactly the same way as a claim under the 1977 Act. And Lord Justice Miles refused permission to appeal on the specific performance remedy. So that reasoning all stands at paragraph 186 and 187. So if you're with me on the passage of property at completion, that reasoning can just be carried over and an order made for delivery up under the 1977 Act. It's not based on specific performance of contractual obligations, it's purely based on property.
But it doesn't, or does it, have anything to do with entitlement to the $500,000 fee? Is it somehow tied up with that, or is it entirely separate?
It's entirely separate, my lord, because it's based purely on a proprietary interest.
Right. And under the 1977 Act, where is delivery up to take place?
I think the Act itself is silent as to that, my lord.
Well, I looked this up in Clark and Linsell, and it has a paragraph which cites a number of cases I haven't looked at, but the basic thrust of it seems to be it's another case where the person entitled to the delivery up goes and collects the goods from where they are. Is that your submission, or is your submission something else? And if so, what's the support for it?
Well, my lord, if that is right, what that means is that effectively, had we been awarded delivery up under the 1977 Act, GFL would have to have gone and collected the gearbox from California. In circumstances where it's now here, the practical implications, it would potentially just mean that GFL would have to reimburse the shipment costs, which is actually, and I acknowledge that, my lord, in my skeleton argument. I note at in the final paragraph, I believe, back to A7. Paragraph 87. Because indeed my lord's point accords with my recollection as well. So if it's right that what should have happened on my alternative case for delivery up in the 1977 Act is that Mr. Carl deliver up wherever the gearbox is, then the reality of that is that now that it has been shipped here, GFL would just have to reimburse the cost of shipment, because that would give effect to that order, or that relief rather.
Yes, right.
Could we look at section 52, which you say is
Yes, of course.
same as 1977 Act? Page
section 52 is in the
10
Sale of Goods Act.
page 10 of the authorities bundle. So the way it works is that by sub 1, you can make an order for delivery, and by sub 3, you can make it unconditional or conditional as to damages, payment of the price, or otherwise as seems just to the court.
Well, just to just sort of carry through how this works, my lord. So section 52 is dealing with specific performance of the sale of goods contract. So my submission on delivery up based on the 1977 Act is essentially if you're against me on my interpretation of the agreement. The point I was making as regards to considerations under section 52 and under the Sale of Goods Act are that when you're considering whether to make an order for delivery up, you apply the same sort of considerations.
Yes, but I'm just thinking about it from Judge Pearce's point of view, that if he had been against you on the fee,
Yes.
and subject to all sorts of other sort of accounting that might have arisen. If he'd wanted you to get the gearbox and Mr. Carl to get the fee, would he have achieved that through Section 52?
He might have, yes, he could have achieved that through Section 52, my lord, and that was actually the alternative case I advanced at trial, which was that if I was wrong about the interpretation of the fee, I'd like specific performance on the basis of we'll pay the fee and get the gearbox. So that was open to the judge, yes. It would be on a different interpretation of the agreement from the one in which he found.
Right, so from your point of view, the priority was to maintain your right to the gearbox.
Yes.
And you obviously didn't want to pay the fee, but you were prepared to pay the fee if you were legally obliged to do so and keep the gearbox.
Yes,
Right.
my lord.
And that could have, there may be many other ways it could have been done, but a fairly neat way might have arisen under Section 52(3).
Indeed, my lord, yes.
All right.
Just to wrap up this point, just the authority for the proposition that the same considerations are made under a claim for delivery up under the 1977 Act and for specific performance of a sale of goods contract it's uncontentious. I provided a Benjamin extract for it. It's tab 38 of the second bundle of authorities at page 842.
What was the page again?
Page 842, my lady.
Did you want us to turn it up now, or were you just giving us the reference?
I was providing you with the reference, but I note that the editors of Benjamin recognised that the court has discretion whether or not to make an order under the 1977 Act. And as to my Lord Justice Jackson's point, the power of the court rests upon a footing which fully accords with Section 52 of the sale of goods.
Sorry, I didn't hear that.
That the power of the court rests upon a footing which fully accords with Section 52 of the Sale of Goods Act 1893 in that situation.
My Lord, my Lady, I think it's Section 3.6 of the 1977 Act, which is on the following page to Section 52.
Yes. Which is the same point my Lord Justice Jackson was making with regard to Section 52. So it could have been made on the conditions. My learned friend makes some submissions in his supplemental skeleton argument that delivery up under the 1977 Act should not be awarded on the basis of the ex turpi causa principle. My short answer to that is that the considerations are exactly the same as a matter of fact as those that concern specific performance, and that argument, or one very, very similar to it, based on the unclean hands doctrine, was advanced and rejected at trial, and permission to appeal against that finding was refused.
That was 188.
Yes, my Lord. With the judgment, yes. Yes. I can address you on my longer answer to that, which is why ex turpi causa has no relevance in this case. But it might be something best for me to pick up in a very short reply on the cross appeal, simply because I'm not quite sure the degree to which it's still being advanced.
Well, We'll see whether Mr. Shepherd has any point to make about that you will then be able to reply to.
I'm grateful. If I might just check.
Certainly.
One point just in response to Lord Justice Mayall's inquiry as to mediation under the terms of my Lord's order granting permission to appeal. I don't know if my Lords have seen the consequentials judgment, which is contained at the back of the supplemental bundle, but a Part 36 offer was made, which was beaten, and the consequences of that flow from in the order that's under appeal. And the findings are set out in the consequentials judgment.
Give us the reference, would you?
But that doesn't address the indication that Lord Justice Mayall's gave that the party should consider mediation.
Yes, so this is also the point that GFL has made offers in the past. As regards mediation, I don't know that no strict attempts have been made at mediation, but I understand that there have been some attempts at WP correspondence which have fallen deaf ears with the other side.
Would it be,
don't say anything further.
because we don't want to spend time investigating this, would it be right for us to approach matters on the basis that neither party chose to pursue the option of mediation after the appeal was lodged?
Yes, ma'am. Right. Unless I can assist further.
No.
Oh,
Yes, thank you very much. Did you want to say something more?
I'm so sorry. My lady asked for the reference to the supplementary, to the consequentials judgment.
Yes.
I don't know if I provided it to you. I'm so sorry. It's the final tab in the supplemental bundle at F20.
Thank you very much, Mr. Hooper. Now, I just wanted to check before we come back to Mr. Shepherd that the screens in relation to the live stream are not showing anything. It may be simply that they've gone to sleep, but can we please check that the live stream is continuing? Good. Right. Thank you. Thank you, Mr.
My
Yes.
lord, my lady, I've been passed a note emanating from my client who's in the United States. Isn't here because he can't be here. Asking if I could ask your lordship for an indulgence of just a few minutes so that I can take instructions from him.
Yes. Yes, of course. How long would you like?
5 minutes.
Well, shall we, so that you're not under undue pressure, shall we return at 3:30?
I'm very grateful.
Could you, my lord doesn't mind me just interrupting.
Of course.
Could you make sure that you are in a position to answer one of the questions I was going to ask you, which is what should be inserted in section 9 of your appellant's notice?
Yes.
All right, 3:30.